Good morning. Today we are going to start with chapter 4, which deals with performance of contract, section 37 to section 67. These sections are there in chapter 4. However, section 37 to 61 deal with performance of contract. Few sections tell about contracts which must be performed. Thereafter, by whom contracts must be performed, means whether joint promisors can perform and all. Performance of reciprocal promises, those provisions are mentioned in section 51, and further few sections deal with reciprocal promises only. Thereafter, we have appropriation of payment, that is section 59 to 61. Okay, now after 62, the provisions are like contracts which need not be performed. Which contracts need not be performed? Those are mentioned from section 62 to 67. Okay. Now see, these continuous sections are there. Section 37 to 61 dealing with performance of contract. What we are going to do here? We are not going to go section wise. We will here go like topic wise or concept wise. Okay. Now what section 37 is telling? First section we will see. Obligations of parties to contracts. The parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed or excused under the provisions of this law or any other law. Like take an example, A promises to paint a picture for B by a certain day at a certain price. A dies before the day, means he has not yet painted the picture. The contract cannot be enforced either by A's representative or by B, because this is a contract depending upon personal skill and volition, and Specific Relief Act clearly states that the contracts which depend upon specific, like special volition and all, special performance of his own will, wish and ability, then these contracts cannot be enforced. These contracts we can't get specific performance. So obligations of parties to contracts, it is an obligation that the parties have to perform the contract, because they have entered into a contract, therefore they have to perform. But if the law, this law or any other law, states that the contract need not be performed, then only the contract will not be performed. Okay. Now what do you mean by performance? Performance means when the parties fulfill their terms and conditions. In a contract there are terms and conditions, rights and obligations which are there for both the parties. Now both the parties, they agree for the terms and conditions and they fulfill their terms and conditions, then that is called as performance. Performance of a contract takes place when the parties to the contract fulfill their obligation arising under the contract within the time and within the prescribed manner. If I promise to sell my house to you and you promise to pay me money, then I will perform my promise by having a sale deed. I am selling my house to you, I am giving the possession of the house to you, and you are paying me. The terms and conditions of the contract for both of them, the both obligations for both the parties have been fulfilled. The contract is performed. Many of the contracts get discharged by performance. Okay, this is section 37. Section 38 is telling about offer to perform, where a promisor has made an offer of performance to the promisee and the offer has not been accepted. The promisor is not responsible for non-performance, nor does he thereby lose his rights under the contract. Why? Because he has tendered the performance, because he did everything to perform the contract. Where a promisor has made an offer of performance to the promisee and the offer has not been accepted, the promisor is not responsible in law, because he tried to perform, he offered to perform. This is called as tender of performance, and tender of performance is equivalent to actual performance. It excuses the promisor from further performance and entitles him to sue the promisee for the breach of contract. So if being a promisor, what I have done, I have fulfilled my promise. I have tried to fulfill the terms and conditions, but you didn't accept. So you are responsible for non-performance. I am not responsible. This is called as tender of performance. But the tender of performance must be fulfilling certain conditions. And what are those requisites? The requisites are that being a promisor, I have fulfilled my terms and conditions. I have tried to fulfill my terms and conditions unconditionally. Means the tender must be unconditional. It must be of the whole quantity contracted for, or for the whole of the obligation. It should be like absolute. I am going to sell you 50 goods, 50 items, 50 dolls, take an example. And I have prepared 50 dolls and I have brought to your house, to your shop to give it to you, but you didn't take it. But I have brought those 50 dolls, means the quantity which you demanded I am bringing. But if I am bringing only 25 dolls, then this is not a valid performance or valid tender of performance. So the requisites of valid tender are what? It must be unconditional. It must be of the whole quantity contracted for. It must be by the person who is in a position and is willing to perform the promise. It must be made at a proper time and place. You told me to deliver the goods at your shop in the morning. So I must be present in the morning in your shop only. Okay. So it must be made at the proper time and place. It must be made to the proper person or his agent. Means I have delivered the goods to you or your agent, not to somebody else. If I deliver the good to somebody else, some third person whom you have not mentioned, whom you have not referred, then that will not be a valid tender. Okay. It must be made to one of the several joint promises. In case of tender of goods, it must give a reasonable opportunity to the promisee for inspection of the goods. If I am bringing a box of that 50 dolls, you are having a right to open the box and check whether the goods are of a specific quantity and quality. Okay. So tender of performance, valid tender of performance will be there only if I give you a reasonable opportunity for inspection of the goods. And the last is what? In case of tender of money, the debtor must make a valid tender in the legal tender money. That is a going currency. The money should be given in a going currency, not the currency, the old currency and all, or the currency which is not in use now. Okay. So I should promise you that whatever money I am giving, that is a legal tender money. Okay. These are the essentials of a valid tender. If these essentials are fulfilled, then my offer of performance will be valid, and as per section 38, I will be relieved from the obligation or from the liability of non-performance. Okay. Now, hereafter what we are going to see? We are going to see contracts which need not be performed. Which contract need not be performed? The contracts which are impossible. They are not to be performed. If you agree for some other contract which is called as a novation, then also contract need not be performed. Or you can say when the contract has become illegal, the agreement has become illegal, or where the promisee neglects or refuses to afford the promisor reasonable facility for the performance of his promise. We have hired a painter. He is going to paint our house. We have told him to come to the house on Monday. He has come, he has arrived with all his equipments and all, but we don't allow him to enter our house. Here you are doing something because of which he is not able to perform his part of promise. So he will not perform, he will go away, and is not liable for non-performance because you have not given him, you have refused to afford him reasonable facility for the performance of his promise. These contracts need not be performed. These provisions are mentioned in section 56, section 62 and all. So we have taken it together under one topic, contracts which need not be performed, where the performance become impossible, where the parties have agreed for novation, that is a new contract, where the promisee dispenses with or remits the performance, where the person at whose option it is voidable, he has rescinded the contract, when the promisee neglects him to give facility for performance, and the last is what? When it is illegal. Okay, here we have not completed the topic. We will continue the topic in the next video. Okay, bye bye. See you.